टेक प्लेस। मकसद ये है बेहतर हुक्मरानी का कि इम्तियाज़ या फिर कोई ऐसा फ़र्क न किया जाए जहाँ तक आला तालीम और उसका निज़ाम ताल्लुक़ रखता है। तालीमी निज़ाम में इम्तियाज़ और फ़र्क की कोई जगह नहीं होनी चाहिए। ये मकासद होते हैं एक बेहतर हुक्मरानी की, जिससे समाज आगे बढ़ता है और तरक्की करता है। साथ ही साथ बेहतर हुक्मरानी तवज्जो देती है कि हम अपने माहौल के तहफ़्फ़ुज़ के लिए किस तरह से काम को अंजाम दें और जो मौजूदा वसाइल हैं हमारे, उनका हम बेहतर और मौसर इस्तेमाल किस तरह से करें ताकि वो न सिर्फ आज के लिए बल्कि हमारे मुस्तक़बिल के लिए, हमारे आने वाली पीढ़ियों के लिए हम उनका तहफ़्फ़ुज़ किस तरह से करें और उनका बेहतर इस्तेमाल समाज के लिए हम किस तरह से कर सकते हैं। आते हुए दावत देती हूँ हमारे फर्स्ट टेक्निकल सेशन के कन्वीनर डॉक्टर सनीम फातिमा को कि वो यहाँ पर आए और प्रोग्राम को आगे बढ़ाएं। डॉक्टर सनीम।
First technical session is Transparency, Accountability in Good Governance, Experience of RTI. डॉक्टर ख्वाजा एम शाहिद साहब का एक मुख्तसर सा तारुफ पेश करूंगी। Management of transformation of a deemed university into a central university is still laudable by one and all. He established and operationalized new academic programs, administrative and legal systems at Jamia Millia Islamia. As a senior officer in the Union Public Service Commission, he handled examination reforms, supervised examinations of different courses in the country. He handled Professor Alec Committee recommendations for the reforms in civil services examination, which now constitutes the foundation for present changes in civil services examination system. Sir had various and wide experiences in development of institutions, educational management, policy planning. Okay. Sir has been as an expert in governing councils. Sir has delivered a large number of lectures on various topics, authored 6 books. Or to be precise, Sir तो मोहताज नहीं किसी तारुफ के, लेकिन Sir is truly a multifaceted personality. We are fortunate enough to have his rich administrative and academic experience at our disposal and his constant guidance at the university. We welcome you, sir, as a lead speaker for the theme Transparency, Accountability for Good Governance and Experience of RTI. Now I request Registrar Professor S.M. Rahmatullah to formally welcome Honorable Pro Vice Chancellor Vikapurki.
Professor Rahmatullah Sahab, Mr. Bahadur Rao, Dr. Saneem Fatma, Dr. Kaniz Zahra, colleagues, students and ladies and gentlemen. My previous speaker, Dr. Kaniz Zahra, has made my task much easier by explaining to you about governance and good governance in very precise and brief but very comprehensive manner. Ladies and gentlemen, I know this seminar has been organized at a very short notice, and the task assigned to Department of Management and Department of Commerce and Public Administration was, of course, to organize this seminar at a short notice of 2-3 days. At the outset, I must congratulate both these departments and their staff and students to do a good job on such a short notice. You all know, friends, that Government of India has decided to celebrate 25th December, the birthday of former Prime Minister of India, as the day of Good Governance Day. Since 25th is a closed holiday, we decided that we will have this seminar on 24th, a day before the designated day, that is 25th December. Now, we at such a short notice could think of only such a discussion among the persons hailing from different background. So you have eminent professors like Professor Rahmatullah from Public Administration, Political Science, Head Department of Political Science and Public Administration, Kaniz Zahra, staff from Dean of the Management and Head of the Department of Management. We have Mr. Bhajarao, an eminent administrator, senior IAS officer, and all of you distinguished academicians and students. In this background, I am standing before you, all of you, and feeling rather embarrassed what to say about this topic. I must confess that I am not very much prepared for this lead talk or whatever word you want to use it. Only last night I could get some time to jot down my thought and some facts and some figures from different sources. So at the outset, let me say sorry if I am not coherent, if I am not well organized, and if I go out of the topic. Some time back I had organized a seminar on right to information. Some time back means say 4 years back on right to information. And we had gathered then Chief Justice of India, then Chief Information Commissioner of Government of India, Mr. A.N. Tewari, Secretary Personnel and many others who were involved in implementing right to information in this country. Why I am talking about this seminar? Because today's topic, as Kani Zahra has rightly said, is about good governance, and one of the most important component of good governance is transparency and accountability. And the regime of transparency in this country has started with the enactment of Right of Information Act in 2005. We all know, I am only reiterating, that we inherited a system of governance from foreign rulers which based upon mistrust, which based upon lack of trust on the people who are to be governed. The bureaucracy, which used to be called civil service or civil servant, was only loyal to the government and not to the common man or to the people. And transformation of this bureaucracy from civil servant to public servant after the achievement of independence was a very remarkable performance of the bureaucracy of the government system. Now we must keep this background in mind to understand the system of transparency which came into existence in 2005. Who was a former IAS officer, Shankar Singh, Nikhil De, and others started working for the welfare of the weak and poor in Rajasthan, in a district called Devdhunguri, which was in the central Rajasthan near Ajmer. They started working for the welfare of the weak and poor, and in 1990 they constituted an organization called Mazdoor Kisan Shakti Sangthan to fight for rights of poor and petty farmers and workers to get their due entitlement. It was a non-political party or non-political organization mainly concentrating on issues relating to livelihood, which directly influence everybody's everyday life, such as payment of lawfully guaranteed minimum wages. The whole issue was like that the laborers were working in a project, say on a road construction or on a bridge development program. The contractors were not paying them full wages. And when they reached or approached the block authorities, they were told that the wages are being paid according to work done by them. So they have not done enough work, therefore they are being paid according to their work. When these organizations came to know about the situation, and they demanded records from the block officer. They wanted the accounts of the development work. Now the block officer told them that this is government account, it's a secret. It cannot be given. Therefore, this is a government document which cannot be shared with you. Now this Sangathan, mainly Aruna Roy and others, they started a program and which they called it Jan Sunwai. Now this Jan Sunwai program was nothing, if I use the modern word, a social audit. They sat down outside the block office, many of them, all these civil rights activists, they sat down outside the block office, called the concerned people, invited even the officers, invited newspaper people, invited the Mazdoor, Kisan, everybody, and questioned the development scheme over there. And they asked questions, they raised questions, and they even asked the officers, if you have any replies, you do, give us a reply. No reply was coming from them, and the answer was always like that, no, it is a government document, and government cannot give information on these accounts. Mind, accounts. Accounts are government document. Now this Mazdoor Kisan Shakti Sangathan, when they demanded to see record, the reply was that there was government account and therefore secret. MKS used the public hearing outside local government offices, and during 1994 to 1995, MKSS organized several Jan Sunwai in district Pali, Rajasmund and Ajmer, and finally in April 5, 1996, organized a dharna at Bewar in Ajmer demanding the right to know, right to life. That was their slogan. So in 1995, they started this dharna with the slogan, right to know, right to life. Many leading newspapers sent their representative to this dharna, including Hindustan Times and other English leading newspaper. Some of them even called it a new war of freedom. Some of the newspapers in the leading reports said a new war of freedom. Ultimately, they forced government of Rajasthan to make amendment in their laws to provide this information to MKSS. And this is the beginning of a movement in this country for right to information. So social activists of this country rightly claim that right to information is started from Ajmer or from Rajasthan, from a small village, from a block level, and many social activities like Aruna Roy and etc., they contributed to the enactment of Rajasthan Right to Information Act 2000. That was the beginning. Thereafter, Karnataka passed Right to Information Act in 2001, Maharashtra in 2002, Madhya Pradesh passed Madhya Pradesh RTA Act in 2003, Tamil Nadu and Goa had also passed legislation on right to information. Jammu and Kashmir has now passed, the last state to enter into right to information is Jammu and Kashmir. The demand for RTI got momentum through the efforts of organizations like National Campaign for People's Right to Information, Parivartan of Delhi, Lok Satta of Andhra Pradesh, Karnataka Right to Information Act Forum, and organizations led by Anna Hazare in Maharashtra. The Press Council of India also played a very significant role in the process of legislation of India because it circulated a draft RTI Act in 1996, which became a very important draft. And Bar Council of India also drafted a legislation named for the right of information. Now these are various efforts before Right to Information Act came into existence in 2005. Why I narrated this story, ladies and gentlemen, I just wanted to tell you that there is a huge amount of social movement, a huge amount of social commitment and social activities participation before this Right to Information Act came into existence in 2005. This is the background which I wanted to briefly tell you. Simultaneously, the judiciary of India, that is the Supreme Court and High Court of India, played a very significant role in promoting right to information. Though, ladies and gentlemen, there is no specific clause or article in the Constitution of India which specifically guarantees right to information to a citizen, but through the pronouncement of various judgments, Supreme Court slowly has led to a regime where right to information had become a fundamental right. It all started in the case which is all of them agree is the case, a famous case of Bennett Coleman Union of India in 1973, when the government of India put some restriction on the purchase of newspaper by the newspaper companies. Now these companies went to the court and claimed that the restriction imposed on the import of newspaper, I don't know, Bhajarao sir must be knowing very well, the newspaper imported till date with zero custom duty, zero import duty. Earlier there used to be huge custom duty on the import of newspaper paper. Till date, now there is no duty on the import of newspaper because it has been considered as a fundamental right of a reader by the virtue of judgment of Supreme Court in this particular case, that publication or printing or freedom of expression includes freedom to know also, and therefore any restrictions on the freedom of expression is an imposition of restriction on the freedom to know. That's for the first time that the Supreme Court said freedom to know is a part of the freedom to expression also, one of the fundamental rights. I will not be out of the place to briefly quote you, if you permit me, briefly quote you Mr. Arun Jaitley, eminent lawyer and a very senior parliamentarian, and now of course the Finance Minister of Government of India. He says in one of his earlier articles, is the source of this right to information merely the Right to Information Act 2005? What is going to argue that right to information has not necessarily come from this Act of 2005. It existed much earlier also, and through the judicial pronouncement. This is what he's going to say in his this article which I am quoting to you. He's saying, is the source of this right to information merely the Right to Information Act 2005, or is it a right that emanates from the constitutional guarantees itself? The Constitution guarantees under Article 19 to every citizen the freedom of speech and expression. The only reasonable restrictions on the fundamental right are those which have a nexus to the interests of sovereignty and integrity of India, the security of the state, friendly relations with various states, public order, decency, etc., etc. He further says, the freedom of speech and expression is a preferred right, even among the fundamental rights. Among all the fundamental rights, he claims the freedom of speech and expression is a preferred right. Its curtailment cannot be on any generalized public interest. On any public interest, it cannot be curtailed. In order to exercise the freedom of speech and expression effectively, you need an informed public opinion. The word is informed public opinion. The right to knowledge includes the right to information. The right to information thus flows out of freedom of speech and expression. The Right to Information Act 2005 is not the repository of the right to information. It's not the only repository, or is not the repository according to him. The Right to Information Act is merely an instrument that lays down the statutory procedures in the exercise of this right. So his point of view is substantiated by other judgment. I will be interested to tell you another important judgment in the history of pronouncement of Supreme Court is the judgment where Rajnarayan, then a stalwart socialist leader, challenged the election of Indira Gandhi, and ultimately he won the case, and which led to the removal of Indira Gandhi, not removal from the government, imposition of emergency in this country. Now, when he asked for certain papers regarding the security of the then Prime Minister Indira Gandhi, the government said it's a secret document, we cannot give you documents on that. Of course, the matter was heard before the High Court and the Supreme Court, and the Supreme Court said so in the famous case of 1975. It's a very important judgment, and which has led to the, of course, as we all claim, forced the government to give a lot of information to the petitioner. The Supreme Court said the people of this country have a right to know every public act by their public functionaries. They are entitled to know the particulars of every public transaction in all its bearing. The right to know, which is derived from the concept of freedom of speech, though not absolute, is a factor which should make one vary when secrecy is claimed for transaction which can, at any rate, have no repercussion on public security. So, the Supreme Court further says, to cover with veil of secrecy the common routine business is not in the interest of the public. So the Supreme Court rejected the idea of secrecy and said it's not in the interest of the public. Such secrecy can seldom be legitimately desired. It is generally desired for the purpose of parties and politics or personal self-interest or bureaucratic routine. So secrecy can be for personal interest, for bureaucratic interest, and so on and so forth. The responsibility of official to explain and to justify their act is the chief safeguard against the oppression and corruption. This is what Supreme Court said. If you do not give information, you justify it, because it's one of the most important safeguard against oppression and corruption. There are many other judgments. I will leave it for want of time. I will only say there is one eminent author, Professor S.P. Sathe. He wrote a book, Right to Information, in 2006, and he went a step ahead. He said this right of information is not only emanating from freedom of speech and expression, but the freedom of equality before law, that is Article 14, and also freedom of life. Because he said many times information is required to protect your own life. Therefore, it's not only right which is emanating from freedom of speech and expression, it is emanating from equality before law, it's also emanating from right of life, etc. Ladies and gentlemen, I have informed you very briefly how judiciary and social activists have played very important role in the growth of this regime of transparency, in regime of giving information to the citizens of this country. I can tell you that this is of course about India, but globally there has been about more than 80 plus countries, or maybe now 90 countries, who have adopted Right of Information Act with different nomenclature. And you will be interested to know that perhaps first act, which was called Press Act 1766, was passed by the Sweden government in Sweden in 1766, which provides a citizen right to know everything or anything without assigning any reason. And same thing, of course, is now given a citizen, that he can ask information, he or she can ask information without assigning reasons. There are many judgments which I can quote, which are available to me, but I will stop here and I move on to my another point. Why we should be very happy about this right of information in this country? Why we should be very happy about this regime of transparency, or regime of, say, as Ganesh Zahra said, accountability, which has come through Right of Information Act, when already, as I said, constitutional pronouncement or judicial pronouncement by Supreme Court, etc., were already there. I will here quote you Mr. Wajahat Habibullah, then Chief Information Commissioner of Government of India. And he said, the right to information opens the doors of knowledge to the people, necessarily the ultimate custodian of power in any genuine democracy. Now, he is linking up right to information to the essential part of a democracy. It allows the public to see what government at every level is doing on behalf of citizens and with their money. Transparency is crucial to accountability, what Ganesh Zahra has just told you. This is what Wajahat Habibullah has been telling us. The principles and rights available under laws on freedom of information, buttressed by judicial pronouncement, provide a powerful reminder that the purpose of the government is to initiative or activist Indrajit Mistry, and he said that the country, the act has the potential to crack down on the corruption on a nationwide basis. Now, this is another thing to be happy about this act. One is, as Wajahat Habibullah said, the part of democracy, and as now Mr. Mistry is saying, it can be used to crack down upon the corruption. Now, you can very well imagine how corruption or removal of corruption is important for our good governance, which has been explained to you by my predecessor. Now, lack of providing information has, over a period of time, resulted in a deficit of trust between the administrator and those who are administrated, between the public servant and the public. I need not to reiterate or highlight this point. We all know how much is the deficit of trust between us and those who govern us. We do not trust a single act, what to say or act, we do not trust a single word of our political leadership, of our bureaucracy, of our policy planners, etc. There is a huge deficit of trust. Now, if we share information, I think the deficit of trust can be reduced. The right of information is very important for removing this deficit of trust, which will contribute towards the good governance and, of course, as rightly pointed out, social development, social progress, and so and so forth. Ladies and gentlemen, information is the most effective right in the hands of a citizen to ensure efficient and good governance. In fact, absence of information from such institution has caused lots of misuse of resources by the holder of such information. One such response was observed during a one-day national convention on RTI. Its caption was "Right to Know as Right to Life, Citizens' Voices." So there are citizens' voices, and this convention where lots of persons from the weaker section, from the lower part of society, they were called and they narrated their own stories, they narrated their own experiences, and this all was documented in the form of I will not say a book, but in a form of a publication. And I have taken a lot of examples from there. This convention took place in 2009, where civil activist Medha Patkar was also present. Kabir, a social NGO, was there. Social Watch, another NGO, was present. Chief Information Commissioners were present. Bureaucrats were present. So, in the presence of media, social activists, information commissioners, bureaucrats, many of these persons narrated their own stories of success. The main objective of the convention was to focus on the use of RTI as a tool of good governance in the hands of common people. The convention witnessed participation of people from backward areas and heard their stories of successful utilization of right to information to solve their simple problems. Now, many stories are there. There was one gentleman named Mazloom. He was a rickshaw puller in Madhubani district in Bihar. The Gram Panchayat sanctioned him 25,000 rupees under Indira Awas scheme, and he kept on begging and pleading for 3 years to get this Indira Awas money. But wherever he went, whenever he went to officials, they always demanded a bribe from him. And then he met some social activists, and they used RTI, and by the use of RTI, ultimately he got his money. Another person who narrated is Pani. She came from a very poor and educated family from Bhartol village in Chitrakoot. And when they found that the children in the school are not getting uniform, which is to be given to them by the school, they use RTI, and in fact this was the case of 27 illiterate ladies who used this RTI and ultimately managed to get uniform for the children of the school. Another name is Kunal Mochi. He was a daily wage worker in Patna. He worked as somebody's farm, and when he went back to ask for his money, he was threatened for life. He lodged an FIR in a Harijan court, but no appropriate action was taken. In the meanwhile, he came to know about right to information and reached the office of RTI Manch in Bihar. With the help of activist Virender Singh, he questioned the police under RTI, got the information, and ultimately action was taken on his FIR, etc., etc. Ramdar, he was in the Bizari village of Uttar Pradesh, and he narrated his own story of how successfully he used the RTA, etc., etc. Bhanumati, Bahraich district, she also narrated her story of how she achieved the desired result in the RTI. Kanhaiya Azad Bhukkar, Ambika Chhatrapati, Altaf Ansari. This Altaf Ansari stays in Firozgarh, Madhubani district in Bihar. And he observed there was a madrasa running in his village. 5 teachers were appointed, but there was no students. The situation initiated him to take action. And he, along with people of the village, talked to the principal of madrasa regarding this matter. The principal was not ready to cooperate and said that the working of madrasa was his responsibility and nobody else is required to interfere there. Then this gentleman used RTI application, got information about the madrasa, the grant madrasa is getting, etc., etc. And ultimately an inquiry was set up by the Department of Education and the corrective measures were taken. Ladies and gentlemen, with these success story, I must tell you there are threats also. There are threats also, and there are incidents reported where we use the word whistleblowers. Whistleblowers are under pressure, under threat. They are murdered. We have stories from Bihar, we have stories elsewhere. The story is no different. When an RTI activist, Satish Shetty, was brutally murdered in Pune, or Vikram Lakshman Dodia, a Surat-based shopkeeper, was killed for refusing to withdraw his RTI application, or Tamil Nadu police snowballed RTI queries on IPS officers' assets. MCD officials in Delhi allegedly threatened RTI applicants and so on and so forth. There are a number of such stories which coming to us where whistleblowers, activists are threatened. We keep reading such stories in newspaper, and there have been lots of studies and lots of reports which I am skipping. I am not going into that. But the only thing I want to tell you that is a very potential tool in the hands of a citizen, where he can question the government, ask for information, insist for transparency, and consequently accountability. This is one of the important part of the good governance. I will not go into other aspects of the good governance. Of course, other speakers will come and talk to you. But only I want to tell you the experience or experiments arising out Right to Information Act, how it came into existence, and how it has been effectively used by people at the cutting edge level, at the execution level. We talk about the scams. They talk about that building scam in Bombay, Adarsh building scam in Bombay. They talk about many where RTI has been used and information is being used, and forcing the government to take corrective measures. Now, finally, I tell you, ladies and gentlemen, that the Right to Information Act is a new law, of course, to this country. But of course, as I told you, there has been a history of some progress. In 2005, when this law came into existence, I was in UPSC. And before the law came into existence, the bill was circulated to all of us. We all were asked to offer our comments on the bill. Now, in UPSC, we all, without any single exception, I can say with some authority, we all felt, what a nonsense law, what a foolish law, how can we work under this law? And UPSC formally met in a commission's meeting, formally requested the Government of India to exempt UPSC from the purview of Right to Information Act. We failed. The Government of India did not accede to our request. This is not my story, this is not the story of UPSC. Mr. Bhalerao may perhaps agree with me. Most of us in government service felt this law will not let us function independently, will not be able to write notings on the file independently. What will happen? Somebody outside will come and question us, why you have taken decision, why you have not taken decision. But ladies and gentlemen, I must tell you, this law has come to exist in the statutes of this country. It's not going to go away. Twice, Government of India tries to amend this law. Twice, the cabinet passed the amendment bills. Twice, during the regime of the previous government, if I am correct to remember. Twice, cabinet passed the bill to amend the act, but government did not find courage or enough support to take the amendment bill to the parliament. There was so much hue and cry in the newspapers, in the media, among the socially activist persons, or the people who are conscious of the right of information, of fundamental rights, or human rights, etc., etc. What I am trying to say that any one of us who is scared of this act must understand, must realize, must tell ourselves that we have to work with this law. And as I told you, there are stories and stories and stories and stories of success of this law. It's going to become stronger and stronger and stronger. If you follow the judicial pronouncements or judgments given by Chief Information Commissioner of central government or the state government, you will see that the ambit of the act is expanding. Earlier, according to act, it's applicable to public authority. Now, public authority is well defined in the act. Now, definition of public authority, I am giving one example. There are many things which I can talk about, but the definition of public authority is increasing. And by and large, now everything is coming under the ambit of this act. Just to give one example, India International Center at Delhi is a trust which is run by a group of trustees. Now, somebody asked information from India International Center. They said, we are private organization, we are not a public authority. We are not supposed to give information. The petitioner went to the court, CIC, and of course it is the court. The court says, you got land from the government at a cheaper rate. So you are substantially funded by the government. Since you are substantially funded by the government, you are a public authority and you are supposed to give information. This is just one example. Now, many private schools refuse to give information, like DPS or many other private schools refuse to give information, saying that we are private schools, we are not government schools, we are not public authority. In the similar cases, CIC and courts gave a verdict that since you come under the purview of Directorate of School Education, and Director of School Education can ask any information from you, you are public authority under the definition of this act. So these two examples will make my point to understand that the ambit of public authority is increasing. Nobody tomorrow, even a private company, can say that I will not give you information, because public companies, private companies come under the purview of Companies Act. If they come under the purview of Companies Act, they are under the extended definition of public authority. So point I am driving at, that all of us must change our attitude, which is essential, which we as a government servant had initially when the act came into existence. All of us has to realize that this act is a very important tool for good governance, for democracy, for all those things which Kani Zahra has mentioned to you in her presentation just before me, and therefore we have to acclimatize ourselves with it. Two important examples of good governance which flow out of the act, I will quickly mention it to you and then I will conclude. One is, the act itself says that all the information should be placed in the domain of the public suo motu, on your own. You need not to wait for somebody to come and ask information. So one of the responsibility on the public authority is to give information as suo motu, and we have to put this on the website, notice board, booklets, etc., etc. One of the important components of this activity is that all the information should be digitized. Now, this one digitization exercise, which will be the outcome of the act, which is given in the act itself, that the public authority should make all efforts to digitize the information available there. Now, digitization will lead to e-governance, and I need not to elaborate that e-governance of late definitely is a very important component of good governance, where of course efficiency, responsiveness, corruption-free atmosphere will come. Now, another thing is that this act bounds us is to organize our information. And organize our information means good record management. Anybody is from public administration, anybody from government service or government experience or any administrative experience, there is no, a good record management is essential for managing the institutional knowledge. Institutional knowledge sometimes goes away with individuals. If I go away from this office, I will take away all the knowledge with me. If somebody else goes away, he will take away all the knowledge with him. Now, if I institutionalize this knowledge, even if I stay or I go away, the knowledge will remain in the institution, whether it's about decisions or orders or rules or anything else. So, institutionalization of knowledge is one of the important components of this act, which is again an important element of good governance. These two examples I wanted to give you, that how this act, apart from transparency and accountability and check on government and participation in the government and using by the cutting edge people and implementation of welfare schemes which I just narrated, this can help in the e-governance as well as the institutionalization and formation. Finally, ladies and gentlemen, I must tell you this is a very unique act. The only act in the books of institute of this country where personal responsibility has been fixed on the officer for non-compliance of the provisions of act. No act of this country, no law of this country put personal responsibility. If a CPIO or public information officer does not provide information, he will be personally responsible. The institution will not be responsible. He will be fined. And the fine, as Supreme Court in many cases, and in the case of Registrar of Banaras University, the Registrar was fined. The university wanted to pay. His court says, no, it's a personal responsibility. Registrar has to pay from his personal pay. So therefore, this is only act which imposed the personal responsibility on the information officer.
So governance is derived from the word govern. And what does the word govern mean? It means conducting the policy and affairs of an organization, of a state, of a society, or a people at large through certain mechanisms of control, influence, and direction. So therefore, governance does not apply only to government, but it applies to all kinds of organizations where a set of people work together, come together, live together. Now, when we talk of good governance, as has already been mentioned, what does it really mean? It means that having good policies and good conduct which goes towards the betterment, happiness and satisfaction of the people. And in the case of government, it means doing public good. Now, what would be public good? Very simplest definition, it would be the greatest satisfaction of the largest numbers. Now, there are certain basics which have already been already mentioned earlier. I just reiterate them. One is, of course, the principle of the rule of law. Nobody is above the law. All institutions or all individuals must be governed by the principle of the rule of law. And there should be good laws. Laws which are closest to public morality and ethics. If a law is not ethical, it's not a good law. But always, all moral and ethical issues may not be covered by law. So therefore, we must draw that distinction and try to bridge the gap between the two. We have talked about the right to equality. Now, right to equality means what? It means equal treatment under the law and equal access to remedies under the law. Now, equal treatment really means that if a people who are similarly placed need to be treated in the same manner. It's not that everybody should be treated in the same way. It's not possible. We are not equal in many respects. But if there is a classification or a distinction made between different categories, then that classification should be reasonable, it should be logical, and it should be based upon fairness. To give a very simple example, today if somebody wants to join the army, there are certain physical standards that are prescribed. You must have such a height, your chest weight must be so much, your chest, this thing should be so much. That doesn't mean that person who doesn't have that can get into the army, because the requirements of army are what they are. So therefore, you can put reasonable classification and restrictions, provided they are fair and they are based on some rational criteria. We have talked about transparency. And what do we mean by transparency? And this is particularly so in the case of government. Decisions must be taken in an open manner, based on some sound reasoning and logic. There is no place for nepotism or corruption. Whatever decision is done, it should be done by a competent person, it should be efficient, and as I said, it should be well informed. And more importantly, it should be in a consultative process, that all sections of society, stakeholders are consulted, and due weight is given to any opinion which may be in the minority. Accountability, we have said, and we know that what really it means is that whoever takes decisions must be identified, identifiable, he should be answerable, and if a good decision is taken, it should be acknowledged and awarded. Bad decisions must face action and be punished. Now, as far as our country is concerned, for good governance, the most important document is really the Constitution of India. And all responsibilities of governance are distributed and shared between the three most important organs of the state, namely the legislature, the judiciary, and the executive. Each has its own sphere of activity. Each has to work in coordination without any what they call as a conflict of interest between each of them. So therefore, legislature, as you know, makes laws, has to make good laws. The executive, namely the government, the political executive and the bureaucracy implements these laws, and the judiciary checks whether the laws are being implemented and whether the laws are good or bad. Now, it has often been said that that government is best which governs the least. And our Prime Minister Modi ji has said, we want less of government and more of governance. Now, what does he mean by that? He says that government shouldn't be doing everything. There is no need for government to start selling bananas or tea or coffee or whatever. The basic function of government or governance is really to set up systems and procedures wherein, as I said, decision making is done for the betterment of public, for public good, and that the most people are satisfied with the result of this governance. Now, what do we mean by ensuring better governance? As Dr. Shahid has already talked about the RTI Act. Now there is a movement to take the matter further, and that movement really is what is called as the right to service. There are some states and many organizations which are working towards ensuring a law which provides a right to service. For example, I want water connection in my house. It is the municipality's job to give me a water connection. That's a service that they have to provide. I pay the necessary fees for it, and then the responsibility of the municipality is to ensure that within a reasonable time that connection is given. Same thing in the case of electricity, same thing with many other kinds of services that. So therefore, the right to service is now a new area where a lot of work is being done, and I'm sure that we need to support such kind of movements. There are some departments and government agencies which have developed the citizens' charters, which again go towards ensuring and telling public that what services they will provide, and if that is not provided, what remedies do they have. Now in our case, in the country, there is, as Dr. Shahid had said, a lot of mistrust. We think that people are going to cheat the system, whereas actually those who cheat the system are only a small number. So therefore, our whole mindset needs to be changed. We need a set of reform the bureaucracy and others. On the Right to Information Act, I remember a person was asked to give information. He did give the complete information. So when he was pulled up, he says, I am being economical with truth. So therefore, this kind of thing is also being done by some of us in the bureaucracy who are quite fluent with our language. Now, lastly, I think good governance comes only by electing good people, electing good political parties, not getting swayed by what they promise in their manifestos or during elections, but what solid work they do as far as governance is concerned. Well, I'll stop at this stage because I'm sure we would have lots of discussion on this. So thank you very much for giving me this opportunity.
It was very informative, and today I think I got the profound knowledge of RTI. My question is, RTI has been implemented from the year 2005, but even though RTI was implemented, the rate of corruption, scandals, scams all over the India has considerably increased in our country. So, does RTI can inculcate honesty in public authorities?
One by one, aim to remove corruption. This is one of the objectives of this act. But it's not the only mechanism to remove the corruption. Corruption, as you said, despite RTI, is a lot of scams and a lot more corruption. RTI is a need to get the information, to bring the transparency, to bring the accountability. Required to be done much more than RTI. As I said, good governance has to be established, and a lot more is required to be done. And one of the most important thing, and Mr. Bhadra has also mentioned, is the mindset. The mindset of the bureaucracy, mindset of those who govern us, which includes policymakers, parliamentarians, executive, and so on and so forth. Unless that mindset is not changed, RTI itself will not be sufficient and enough to remove the corruption. But it's one of the important tools in the hands of citizenry of this country to use it and to check on the governance of the country. I agree that a lot more is required to be done beyond rate of this RTI is one of them. Now, I must also add that RTI in itself is not a grievance redressal mechanism. It's not a grievance redressal mechanism. As Mr. Bhajarao says, now there are more things are coming into force like citizens charter, like right to service. You have to tell your citizen that if you apply, how many days reply will come and how many days work will be completed. So rights of a citizen to know about his whatever he wants to be done from the government is coming into force. All these laws, and once they are in force and when this regime come into existence, will definitely improve the accountability of the government or the executive, which hopefully will lead to a less of, I will not say corruption free, but less corruption in the governance. And Dr. Shahida, you had talked about ethics and morality. Will you please repeat your question? I missed it.
Yeah, I just said that RTI does give power in the hands of the people.
Yeah.
Definitely. But what is happening when it comes to the freedom of expression? You see all type of things are being expressed. Even India's integrity or whatever you said, the respectability was at stake at one point when the painter did something or somebody expressing somebody.
Justified. And any right, and particularly there is a saying, those who belong to law, that you have freedom to move your fist in any direction till somebody's nose starts. So you're not going to blow somebody's nose because I have freedom to move it anywhere. So it is it's a well-established principle of jurisprudence that you have freedom to move your fist anywhere till somebody's nose starts. So you cannot hit somebody else. So whether it is freedom of expression or freedom of your religion or practicing any religion, it should not be used to cause whatever you're referring to hurt others, to hurt the sentiments, etc., etc. All rights, and those who are from legal background sitting in this hall, otherwise, all rights are not without reasonable restrictions. This is a well-known principle. Whether it is freedom of expression, whether it is freedom of profession or religion or life or anything, is not without a reasonable restriction. This word is used by courts repeatedly. And what is the reasonable restriction is being interpreted time and again in different judgments and in different pronouncement by Supreme Court and High Court. Even right of information, which I talked about, has restrictions. We can deny information under Section 8, under various exceptions like the security of a state, like friendly relationship to neighboring countries, by the diplomatic relationship, so on and so forth. Even agreement with foreign countries or things like that. There under Section 8, there are 9 or 10 clauses are given where this right of information can be denied. Simultaneously, there is a very strong presentation for right of secrecy also. And it's coming, and the Government of India has put on its website a draft legislation or a white paper on the subject. Not draft legislation, a white paper on the subject. And they are now talking about that along with the right of information, there should be right of secrecy also. Now, secrecy is a term which is very relative. For me, something maybe my private right or private secrecy, I want to retain it. For example, as they say, in Western world, if you ask somebody's, what should I say, caste, they don't have a caste system, they ask somebody what is, it's a very insulting thing. In our country, telling our caste is something we feel proud of it. I am Sharma, I am Srivastava, I am so and so forth. Now, this is a social background, so secrecy or personal rights or for example, somebody can ask, and such questions keep coming to us about the medical reports of the government officers. RTI we receive that somebody has been selected as some officer or professor. What is the medical report? Now, should I tell him that his blood group is B+, he's suffering from arthritis or things so forth? It's a personal information. So again, there are a lot of curtailment and things being talked about. So any right of information does not amount a license for any violation of such rights, which may lead to rights.
Shahid has said, a lot of instances of even the misuse of the RTI Act have been coming up. To be a very close and recent example, we got a letter from Uttar Pradesh asking all the details about the residential coaching academies in all the 5 centers where it is being held. Now he has asked, questions like, give the name of each and every book that is there in a library. Who is the publisher? What is the cost? Did you negotiate and bring down the price? Then he said, in the hostel, what menu is given every day? What is the cost to each? Now, he has asked about 30 odd such questions. Now, surely he is somebody who is involved with the academies and therefore he has some axe to grind. And therefore he is asking all these questions. So such kind of misuses are also coming. And in fact, statistics have shown that almost 70% cases are those government officials themselves asking questions about their own cases. So that kind of misuse does occur. But nevertheless, just because some people are misusing it doesn't mean that the act is bad or it should be thrown out. And in fact, this act is another wonderful example. I keep telling everybody whenever I have such occasions to address gatherings that even it is good for the bureaucracy, because now people will know who has taken the decision. If a certain officer is transferred from X to Y place, he doesn't know who has passed that order, whether it is the secretary who has done it or whether it is the minister who has done it. So therefore, now in the file it will all be noted who has done that decision, why he has taken that decision, and therefore, people will get exposed. So this is a good way of where even corruption can be brought down. And accountability doesn't necessarily mean bad thing. It also means that there is a protection to people who are taking decisions. That if they are taking decisions in the right way, they will not be harmed or suffer from any problem. And as I said, freedom is the most cherished right that we all have. Some of us tend to misuse it. But then, see, there must be a system where such misuse is detected and punished. Now, with due respect to media, they have been going overboard on many issues. Because they want fights, they want something to fill up the paper, they will misquote or even put words in the mouth of some people who don't say anything. So this kind of thing is happening, but we have to live with it. And I think over time things will change. Thank you.
Thank you, sir.
Now I am going to reply, but just I want to share some observations regarding corruption. Just I am remember that Kautalya in his Arthashastra, he said, just as it is not impossible, just as it is not possible not to swallow the bit of honey that happens to be on one's tongue, it is impossible to eradicate corruption. So it was his observation. It does not mean that we should not keep quiet. We have to struggle, we have to try. So this is what some observation I want to share with you. Thank you.
Thank you, sir. I request Professor S.N. Rangila Sahab to also present a memento to Mr. S. Bhale Rao, discussant and Sanskrit.